And if I'm a solo artist, I don't have a band. I'm just a solo artist. Should I register my trademark?
Well, what's your trademark? Is it just your name?
Yeah, just my name. Yeah.
You can.
Nickname actually.
I'm sorry.
Nickname.
You should. Frankly, I mean, you should, because you're using it, and they'll ask you. The PTO has rules about that, and they'll ask you as a person if this is the name of an individual, do you have their permission, or have you obtained their permission, and you tell them yes or no, and they may ask you for a statement saying I am so and so, and it's my name. But if it's a nickname, like for instance Lady Gaga, that's not a natural person's name, that's her name. I'm sure it's registered. So if you have a nickname, register it.
Okay.
You said early on there were resources for searching how much to see if a trademark's in use. Where are those and what do they cost?
A proper search, like CT Core Search, CORSEARCH. And to get a search from them, and you can find them online at coresearch.com, but to get a search from them, a comprehensive search, which is, now permit me to get a little bit arcane here, my apologies, but there are two issues you have to think about there are actually three, with trademarks. Of course you don't want another identical trademark out there, okay, that's good. But the standard is, confusing similarity. So is the mark identical or confusingly similar? And the cases for confusingly similar, you don't have to be exact. I mean, you can have actually pretty significant differences. But, for instance, in trademark law, there's something called the doctrine of foreign equivalence, where if you have a foreign mark, just say Lupe in Spanish is wolf, and you want to register that for a band, Lupe, okay? But there's another band in the U.S. called Wolf. The U.S. will refuse the application for Lupe, because Lupe has the same meaning, and the standard is, a native speaker of that foreign language would understand what it means. So and then also just if it differs by a word or two, or sometimes if you have a dominant element, if you're, for instance, using, Aqualife versus Aquavita, they'll say those marks are confusingly similar. So you have those two standards, and there's a third issue here, which I didn't mention, and that's dilution, which is something trademark law is, in my view at any rate, is very tilted very heavily in favor of big owners and large companies. If you look at where the law is developing, it pushes it. You have the International Trademark Association, which is an organization I belong to, but they do tend the big members, the big sponsoring members, tend to be very large corporations. They pushed through a law back in 1996, the dilution statute, which protects famous marks. And so the idea there, for a standard infringement argument, you have to have an identical or confusingly similar mark used for related products or services. Okay? For dilution, if a mark is really famous, and it is a pretty high threshold of fame, it has to be truly famous. But if a mark is really famous, you can enforce it against someone using the same mark, even if the goods are completely unrelated. So if you're Kodak, and you're Kodak, you do film, you do all the things, and now I want to do Kodak for, peanut butter cups. Kodak, the film company, can come after me for using peanut butter cups because of that famous right. So you can't get cute with these things, and a lot of people do. And I'm always amazed what people do, because they think, oh, no one will ever know. They'll never find out. I was just met with a guy today. He was saying, I'm going to do this. Oh, we're small. No one's ever going to find out. You know what? They'll find out. And, I swear to you, just last week I had a client, a small guy who picked up, before I ever got involved, picked a mark that happened to be a mark used by a major big pharma, $3.2 billion company. And he kind of, I don't know why he was doing it, but he picked a fight with them. And they came down hard and heavy on him. They're going to kill him. It was unfortunate. So these are the sorts of things you really want to avoid, because these guys play rough. They play rough.
Is that what happened with Apple, the record label, and Apple?
They came to an agreement.
Really did?
Yeah, they came to an agreement. I believe. Is that right?
Eventually, yeah.
Eventually, yeah, right. They came to an agreement. Yeah. But they were also two big players. They were two big boys. But when it really gets ugly is when you have a big boy versus a little boy. And even if the little boy is right, the big boy can spend him into the ground. And it's inequitable. It's very inequitable, but it does happen. So Those are issues, and you have to know these are serious issues. I mean, you put all this time and money into getting your name out there. You want people to know who you are. And then suddenly, maybe you're a year or 2 years into your project, and suddenly you get some traction. And then suddenly somebody pops up out of the woodwork and says, hey, you're using my mark. And, there goes all of your goodwill. I mean, and you can change it, and, if you're creative about it, you can actually make it work in your favor. But you don't want that to happen to you. You don't want that to happen to you. So my takeaway of all of this is be careful. Do a proper selection. I mentioned core search. There's Thompson. Thompson also is another company. Those searches, just to get back to your question, Corey, the big comprehensive searches, which can be several inches thick, cost about $650 to get. If you do it on a regular turnaround, if you need it expedited, it's over $1,000. But they're about $650. But they give you not only the identical marks that are out there, but the confusingly similar ones, marks that are similar. Maybe they begin with the first 4 letters or have some element, they share some element. They're very good searches, and they can miss something, by the way. I should tell you that. They can miss stuff. But they often don't. They give you the highest level of assurance that you can possibly get that nothing else is out there. There's always that, lawyers have weasel language that we use in our letters that say, based on the available information, this mark should be available for use as proposed. But, you use that language because you never know. I mean, I had a search where it was, I was working for a law firm. We were doing Disney stuff, and Disney wanted to use this mark, March of the Articles, and they were going to have these very fanciful articles, and they were going to perform that at Disneyland. And nothing came up in the big 6-inch thick report. And then, using Google, we were looking around. We found a little woman. I don't know her size, but she was a little operation in Florida, working out of her basement, doing tie-dye T-shirts of Artemis, and she had Artemis, and she could have editor rights to go hit the deep pocket, and she could have caused Disney a lot of heartburn. So we advised Disney, don't do it. This woman's out there. We can't do it. It's another plan shot to hell. But we probably saved Disney a lot of money. She would be saved. But it's always the little. The little characters, and you can't always rely on the fact. I see so many people doing this, saying, they won't bother us. They might, and if you start getting some money, they will, because you're going to be a deep pocket, and people love to sue in this country. I mean, it's just the reality.
Do we have any other questions? Trademark or anything else? Anybody else looking for legal advice? Free legal advice? Take advantage.
What if I have the name of the song that is someone else also use similar name of their song? Is it okay?
Song titles are not protectable under trademark or copyright for that matter. It's a song title. I mean, that's kind of comes up. Titles are protected if you have a series of books. Harry Potter, or something like that. Then Harry Potter becomes protected as a book. Or if you have a series of songs, if you're doing a series of songs with a certain title, if there are multiple titles, your multiple songs, if it's a series that comes out regularly, well, that's protected. But a single song title. Sorry.
Go back.
Linda?
Yeah, is that okay? We have a song that recently we were contacted by the company that does a lot of licensing for like Desperate Housewives and these big shows, and they wanted to use one of our songs. So they wrote to us and they said, we really like one of your songs from your EP. We want to buy your publishing. We want a publishing buyout. So I called a lawyer friend of mine, and he said that no matter what they offered us, whether it was $5,000 or $30,000 or $1 million, that we should take it because as long as we retain the rights to perform it and we retain the rights to keep it on, our EP, that the popularity of the show and the use of our song would far well pay for itself.
That's a business decision. And, I guess your question is...
Does it make sense to sell your publishing? Because I mean...
Does it make sense to sell your publishing?
We just never thought we'd have to sell
I would...
rights.
It strikes me as something, as a musician, a composer, it's something you wouldn't do. I mean, generally speaking, you do have a music publisher, but you split, your revenues are split between the publisher and you 50-50. But even then, you assign your certain rights to the publisher, which last for a certain period of time, and you can get them back. For Desperate Housewives to ask for the publishing, that seems a little bit crazy because they're sort of really a third party outside of the music industry in some level.
I guess the woman who was the like the person, like the agent who does the song. So when she emailed me and she said, did you publish this? And I said, we self-distributed, we self-published it, released it in the EP through iTunes and Amazon. And then she got kind of weirded out and said, you published it with someone else or by yourself? I said, we did it by ourselves.
Right.
And then she said, okay, that's great. Has anybody else used the song in a movie or television? I said, no. She said, we're very interested in the song, we'd like to use it, but we would want to do a publishing buyout. And I said, I have to think about it. And then I called every friend I had that was a lawyer and asked them for their opinion. And we talked about it, and I just wonder, like, typically, if, like, we're nobody. We're not Lady Gaga, we're live.
Yeah.
You know what I mean? So, what's our strength? We have the power to say, we're happy to let you use it, we're happy to never make money from it, but we want the right to play it live and keep it on our EP.
I mean, I think you have every right to say that. I mean, you probably have an opinion on this as well, I would think, yes?
Yeah, I work on a lot of licensing deals with clients. Generally speaking, I wouldn't go for that. Well, it like Lou said, it's a business decision.
Yeah.
I mean, if they offer you $1 million, then yeah, sure, it's worth considering. Part of the problem, though, you have a lot of cons there. One of the cons is you should get some kind of rate for the actual license, so for the master side and for the publishing side. You keep your publishing and you get public performance royalties off of the use in the show, which is why it's a little weird, especially if you have an agent for the show who's trying to buy out publishing rights. Maybe it's because they expect to get the back end and that it'll exceed the amount that they're offering you at the time, which is entirely likely. If they're offering you $5,000 on a syndicated show, right, then what'll happen is every time that gets played in the station, it gets played on, or basically anytime it's publicly performed, you get royalties back from that. If they bought you out on those rights, then they may very well exceed the rate that they paid you for the rights in the first place. Quite likely will if they're making the offer in the first place, which makes it a bad deal.
So it sounds like worst case, put a timestamp on it, so they can abuse it for 3 years, but then you get it back. Or something. I've taken advantage of that before.
Yeah, I mean,
so at least they don't own it forever.
But one of the business considerations that you have to think of, what would it do for your career?
So the idea is if they use that song, I don't know how, she said they wouldn't even talk to us unless we were open to the concept. So of course we said we were open to the concept, so that we could.
It strikes me as sort of, I mean, why don't they just agree to license it from you? Give you a license?
It is odd, and what I've seen has been the opposite, really, where they'll make an offer. I have one client, for example, that was recently on Skins, the TV show, the first episode. And what they do instead is they say, we're gonna give you a very low fee, and you keep all the performance royalties. So that's where your income is. That's your incentive to license it. It's the exposure and the back end, and on the front end you get very little. So
I have no idea what they're going to offer to us, but I was just concerned in general.
We just have to be prepared for the conversation.
Well, I remember hearing a Regina Spektor tune on some show. I forget what it was, but this is before she really sort of broke through. But I remember that, and I would love to know the details of how she, of what they did. Did she make it? But it was one of her popular songs that was on her CD, so she was getting royalties from it.
Yeah.
I'm sure that she must have licensed it, and just giving them a license. It strikes me as, maybe what they're trying to do is sort of they want to get all the royalties themselves. They're hoping to make get the song and then make their own money from it. It does strike me as very odd. It strikes me as something a little bit unholy at the end of the day.
Let's move on to another. We've got, I think, 2 more questions. You said you had one?
Oh, you had a question.
I guess with tunes, like you could have like a name of a tune, like I have a tune on my CD. It's called Fire and Ice, and and a friend of mine looked it up and said, Pat Benatar did a tune, Fire and Ice, and Yang Bay Mongsing, Fire and Ice too. But I guess you can have as long as, and it's copyrighted under a work, the whole thing. I guess it's okay as long.
That's all right. I mean, the songs are the copyright. You don't get a copyright in the title. You don't get a copyright in the title. And you don't get a trademark in the title.
So I understood it as that you could have more than one.
Yeah, no. I mean, really the copyright goes to the content. If your song is exactly like Pat Benatar's, well, then you're screwed. Okay.
Right.
And and if you start calling yourself Pat Benatar, well, then you have a problem.
Right.
But many actually.